Hello and welcome to this video on how to apply the law on occupiers liability. This will focus on lawful visitors under the Occupiers Liability Act of 1957. If you have a problem also on trespassers, there is another video available on this channel which will cover that particular topic. A little overview before we start then. So this is designed for A-level law students, in particular for my students who study the AQA law syllabus. It is equally applicable to those studying on other A-level syllabuses, and of course other courses such as BTEC or CILEx. If you're applying negligence, you can use this video to help you doing it one of the first times you do it. You can use this video to help you do focused revision if necessary. The video itself will focus on structure then, but will primarily focus on how to apply the law. So with that, in terms of explaining the law, in terms of recall of knowledge, this does assume a little bit of prior knowledge. This shouldn't be a video used for the first time when you're learning the topic. It's when you're looking through how to apply the law. So piece together your knowledge of the law plus this video, which should help you apply the law, and then you'll be okay. Now, of course, you can use this video all the way through. You can go back, rewind, forward, wherever you need to go. If you're doing a question on a particular element, you can just look at this video for that particular element. But about halfway through, we'll go through a worked example and show in practice how that works and how I would apply the law. So a little bit on structure then. If you watched any of my videos, you'll see IJAC is the structure I use for applying the law to particular situations. I just means you need to identify the problem in the scenario as one of occupiers liability, and in particular lawful visitors under the 1957 Act. We then define what occupiers liability is in broad terms, just to give us a framework to answer the problem question. You then need to explain the law. Now with this particular topic, you would only explain the elements which are necessary. We'll come to that later and which ones to omit in which circumstances. And then we apply the law, so explain each element, apply each element. That's going to be the best way to go. Always using case law and authority to support, and indeed as well you need to analyse as you go. So in a particular situation, weigh up the possibilities and fall down on which side you think the argument is going to fall. That is going to ensure you reach the higher level marks. Then we need to conclude. So in terms of conclusion, make sure we know there's going to be liability or no liability, and if there is liability and it's been breached and the damage has been caused, there are no defences, and outline in those longer form questions at least remedies. So there are some things we need to consider before we kind of delve into the Act. We need to start off with considering who are we going to make a claim against. So in this scenario, this will be outlined. Somebody will control premises. So identify the occupier and who that is according to the rules laid out in the Acts and in common law. Now this is a little bit of a cop-out in the sense of 1.2 tells us rules of common law shall apply. What that tells us though is that Parliament were quite happy with the common law at the time as to who is an occupier. And in essence, this is broadly speaking a degree of control over the premises. Now you can look at Wheat and Lacon for 4 additional categories, for example landlords or tenants and so on, so you can use those to help you identify. In terms of premises then we need to consider what is premises. So in terms of premises then we've got an example from 1.3a which tells us a fixed or movable structure including any vessel, vehicle and aircraft laid out by section 1.3a. So it's quite a broad kind of definition. Notice different then, there's more added to this vessel, vehicle, aircraft than there is for trespassers. And you consider this because trespassing usually occurs on land. So we need to identify the premises then. So when we've done that, we need to consider in your scenario there might be more than one potential claimant, so make sure you go through this for each particular person. Identify whether the claimant is a lawful visitor or a trespasser. Now there might be more than one potential claimant in each scenario, and we need to go through what type of permission they have to be there. Now deal with this in outline only, it's not taxing, you'll come up with an idea here. Some examples of express permission is if you've been invited onto the premises or you've got a contract, for example, a ticket for a concert or you booked a holiday. So you have a right to be there through a contract. Implied permission could be such as repeated visits which are unchallenged, so you gain a license to a premises. Now this could be, for example, using somebody's premises as a shortcut for a certain number of years. If there's an allurement as well, so if there's something attractive to children that brings them onto the premises, then this may make the child a lawful visitor and not a trespasser. If you're going to communicate as well, so this could be like police, for example, if they need to come and speak to you, they're allowed in your premises. And statutory right, again, the police have a statutory right in some cases when, for example, they might get a warrant to enter your premises. So there are many kind of statutory rights. You will, in your learning phase of this topic, you might come up with more than that. So once we've established who we're claiming against, once we've established that it is premises, and once we've established that the person claiming is a lawful visitor, then there are 4 things we may need to consider. Now, we don't need to consider every single one of these for every single time you're going to apply the law. So your analysis skills will identify which you should use in each scenario. So we've got a common duty of care. Now this always applies. So this is the one you always need to go through for every single person making a claim under the 1957 Act. The others only apply if they need to. So the claimant won't always be a child, the claimant won't always be exercising a trade or calling, and the claimant won't always be injured because of the negligence of an independent contractor. Well, we've got to carefully and forensically examine the situation. Do these apply? We're going to go through how that happens in a moment, but for starters we're going to look at this common duty of care. So what we need then to do is to explain what is the common duty of care, and this is a duty to take such care as in all the circumstances of the case is reasonable to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there. So there are several facets to this. We need then to consider the thing that kind of comes out is reasonable safety. This isn't perfectly safe, this is reasonably safe. So you've got to make a judgment in this scenario. Do you think the person was kept reasonably safe? And if it's not, then we should say that. Now remember, it's the visitor who must be kept safe, not the premises. So for example, a shop might mop the floor, might absolutely keep it reasonably safe, but in the back you've got all sorts of boxes and bits and bobs which could fall and harm people. Now you don't need to keep a visitor safe to visit them because there's a trespasser there. So in the places they go, that must be kept safe. Indeed, another facet to that is the premises for purposes for which is invited or permitted. So what we got there is the Calgarve kind of example of you're allowed to go into somebody's house to use a staircase, but not to slide down the banister or slide down the staircase. You're not allowed to do that, you become a trespasser at that point. So it's taken into account, is the person doing what they were supposed to be there for, and are they reasonably safe at that point? So then we apply this to a situation. The visitor must be safe, not the premises, and use a case as authority where possible. Now case law is quite important. For lawful visitors then, so we've dealt with this one. You may need to consider if the claimant is a child. If they're not a child, then we do not need to explain or apply this. Okay, we need to make sure we are forensically analysing the scenario before even beginning the question. If the claimant is a child, however, then we need to be prepared for children to be less careful than adults, and as a result, the premises must be kept reasonably safe for a child of that age. This is explained in section 23A of the 1957 Act. What this means then is essentially a higher standard of care is expected of the occupier. So if you invite a child onto your premises, for example, you have neighbours, you have friends and they have children, you need to make sure the children are safe, so don't leave things out which are dangerous. In your scenario, could the person have done something to make the child more safe? That's what we need to be asking. Now consider then whether the premises contained an allurement. So this is something a draw or something dangerous and attractive. Now if there is something which is a draw or dangerous and attractive, then we need to make sure this is not attractive or that the person, the child in this case, cannot access it. In some cases though, the parents might need to supervise the child. So in this particular context, we mean there are certain things or which a parent should do to stop the children going into certain places. So that might be remove liability for the occupier. And again, we need to consider any similar facts or legal principles in your case and which support your case. And the cases, just as a matter of course, should be something you discuss in your explanation phase as well, and something which you should have learned. Now, if the claimant's a child, the person is almost certainly not going to be exercising a trade or calling. So of course those two would never normally apply with the same claimant. However, you may get multiple claimants, so you might need to consider this too. So the person is a person exercising a trade or a calling, for example if they are an electrician or a plumber. Then an occupier, the test from 2.3b, outlines that in the exercise of his calling, the person will appreciate and guard against any special risks ordinarily incidental to it, so far as the occupier leaves him free to do so. So an electrician may do certain things to avoid himself being electrocuted while working on wires, for example. A plumber may turn off the kind of taps in the house to ensure that when he's working in the plumbing he doesn't get injured, or he secures things in place to make sure that when he removes parts he doesn't become injured. Now in many cases that's just kind of accepted. So apply this test in your scenario. Is the person who's going on and claiming, are they doing their job? And what are they doing their job in a normal way? Now this person should be competent. So if he's not competent, it's his own fault. Could the claimant have guarded against any foreseeable risks? So if you're an electrician, you may ground yourself, or you may wear gloves which don't conduct electricity, for example. But if the risk is not related to the work or it's unforeseeable, then there may be liability. So in this case, let's say you have a situation where you have somebody coming around to your house and they're working on your gas fire. Now while working on your gas fire, a mirror falls on them from above them. That is not relating to their work. They shouldn't have to remove mirrors which are loosely fitted. So that would make the occupier still liable. It's not related to the work they're doing. And again, use case authority where relevant. We need to make sure we are doing that at all cases. So for example here you may use Rolls and Nathan to support your point. And the final consideration is if what if the claimant's injuries were caused by the negligence of an independent contractor. So this is a way in which the occupier may seek to discharge his duty, in essence saying it's not my fault, it is the person who did the job's fault. So if somebody comes around and does your electricity, and then your friend comes around your house and is electrocuted when he tried to turn the light on, then it's within reason at least, it may be the fault of the independent contractor and not you. Now again, you should make sure you study this before applying the law in order to be able to explain it before applying. Okay, so if somebody has worked on the occupier's premises but has done the work negligently, then that person may be liable instead of the occupier. Now the test laid out in 2.4b is the occupier is not liable for damage caused to a visitor by a danger due to the faulty execution of any work or construction, maintenance or repair by an independent contractor who is employed by the occupier. So what this means then, we need to apply 3 tests. We need to look at, was it reasonable to entrust the work? So if it's that person's job, there are usually clues in your scenario which will give this. He's an experienced mechanic, he's an experienced joiner, experienced electrician, experienced plumber, or the words to that effect. However, it won't be reasonable to trust it to a friend, for example. So the case we should use here is Hazeldine Dawson. The next step is to consider, is the contractor competent? Now Bottomley and Todmorden Cricket Club is the case to use here, but we should again just usually that will be given in that particular kind of wording of the scenario. You should be identifying whether they are competent, and that can be experience, or it can be, if it's something entirely related to the normal job or skill set, then it won't be competent. And finally, the occupier, if possible, must inspect the work. Now, there are certain things which you could inspect. Faulty wiring, you could inspect carpet fitting, you could inspect how stairs have been built by maybe stepping on them, for example. And again, you need to analyse in your situation, did the occupier inspect the work? And we need to analyse this as much as possible. But there are things which you might not be able to inspect, which is why you get people to do jobs in your house, because you may not know much about how to do them. And we're talking house, but it could be any kind of premises here. So, for example, if it's on the roof and the tiles have been done, you probably can't inspect your own roof. So we need to be careful about how we approach this. And so that's the kind of main issues discussed. But again, we need to do a light touch. If you've already watched the video, on trespasses, then you will know that we need to do a light touch in terms of breach of duty and damage as well. Now, this is a similar kind of tort, isn't it, to negligence, in that we're establishing a duty, but we also need a breach and damage. So again, light touch. If your occupier has fallen below the duty expected, you might be liable. So apply this to the scenario. A couple of sentences will be absolutely fine. We also need factual causation, so knowing what you know about causation in tort law. First of all, factual causation, the but-for test, and any other attachments to that, and then when the damage is foreseeable in this particular case. So make sure you go through them again in a light touch format. So then, if we do have liability, if the occupier has fallen below the standard expected of them, then we may need to consider any potential defences. So is there anything in the scenario which you feel has tried to either remove liability or limit liability, or the claimant has done something which almost makes it their fault, if possible? And to do that, we've got kind of 4 key areas here. We've got warnings, contributory negligence, voluntary, which is consent, and exclusion clauses. So looking at this first one, we need to state and apply to section 2.4a, and this says a warning relieves liability, so therefore the occupier would not be liable, if in all the circumstances it was enough to enable the visitor to be reasonably safe. Sometimes though, a mere warning will be insufficient to safeguard the visitor, in which case the occupier remains liable, and to avoid liability he will be obliged to set up barriers instead. So this could be physical barriers, it could be locked doors, it could be warnings, verbal, physical warnings. You can give express warnings, for example, a sign. Okay, so you've warned people not to go in there by saying a sign. But it can also be implied, so if it's a locked door or a very high fence or barbed wire, for example, then this is a sign, isn't it, to say don't come in here. But some risks are so obvious that no additional warning is needed. And so again, you need to look at your scenario, consider, even just if you use your own judgment, was the risk obvious? Now make sure you follow a case authority where possible. So in terms of warnings, we need to make sure we are using, for example, Westwood and Post Office. Now, contributory negligence is where the claimant will have contributed in some way to their own negligence. And so again, using what you know about that defence, this is outside the scope of this particular video, but make sure you use contributory negligence and see, did they contribute some way? As with consent as well, so consent, did they willingly accept the risk? Now, there are tests laid out, and you can either watch a video in this one, how to apply the law for defences, or you can go and use your notes to ensure you do this. Now, exclusion clauses, state and apply subsection 2.1. I hand out a summary sheet for this, but of course you may have your own notes. Under section 2.1, exclusions are allowed by agreement or otherwise, so liability can be excluded by terms or by communicating a notice. Now, There are various restrictions, however, so they can include excluding liability to persons entering by legal right. They might fail against the children because they don't understand them. We need also to consider Section 2(1) of the Unfair Contract Terms Act, which limits how they can be used for death and personal injury. They won't apply in the case of strangers, so if a stranger doesn't know, he's not connected to the contract, then he won't know. But also, there's also an argument that since Occupiers Liability Act of 1984 imposed a minimum standard of care of the trespassers, then also this minimum standard should also apply here at the very least, so exclusion clauses can be very limited in their effect. In any case, unless you're using or watching this video at the end of your A2 course, you may not yet have covered exclusion clauses and the nuances surrounding them. But if they've got an exclusion clause in a contract, which is unlikely, I think, in an exam scenario, but it may come up, you never know. So we need to make sure we're going through this and identifying was there an exclusion clause and can it be used. Okay, so we now come to the conclusion element. We've done the identification, we define the law, we've explained the law using your excellent explanations, and we've applied using this video to help apply. Now, is there potential liability? We need to conclude. Is the potential liability under the Act? Are there any potential defences? And if there are no potential defences and there is liability, then what are the possible remedies? Now, in the longer form question, you may need to go through each of these in turn as to what type and so on, and how they're awarded. So if you're watching this video to help you with a particular problem, go back to the beginning, work your way through, and use this as a kind of audio guide if necessary. However, this portion of the video will go through a worked example. Now, there are several examples in one particular question. Okay, so this scenario then focuses on, and this scenario was borrowed from a colleague because I couldn't think of a better one myself, which outlines most of the key issues. So thank you to that colleague. However, we've got some Simpsons here. So Homer, Marge, and his children Bart and Lisa go to the Springfield holiday camp for 2 weeks in August. The camp is owned and managed by Springfield Leisure Company. A note here, obviously if you're a fan of The Simpsons, you know this is American. Let's assume this in England for the sake of argument. So, late one night while returning to the holiday chalet, which is high up on a slope, Homer falls down the steep steps that lead to the chalet from the road below. There's no guardrail to the steps and the steps are unlit. Homer suffers severe head injuries in the fall. Our second claimant, Marge, is electrocuted and badly burned when she plugs in a kettle in the chalet's kitchenette. The socket's actually been left live due to the negligence of shoddy electric company who recently rewired the chalet. Our third claimant, Bart, cut himself badly and wrecks his jacket with a sharp knife when he sneaks into the kitchen in a camp restaurant to make himself a sandwich. The door's not locked, but a notice on the door of the kitchen reads, "Danger, staff only." Lisa then, our fourth claimant, suffers an upset stomach when she eats berries on a bush growing by the chalet front door. The berries are poisonous. Now our question says, advise Homer, Marge, Bart and Lisa if Springfield Leisure Company is liable for the injuries. Now the very first thing we need to do then is analyse in this occupiers liability scenario, who is a lawful visitor and who is a trespasser. Now we can go off the bat. Homer, lawful visitor, is on holiday. Marge, lawful visitor because she's on holiday. Bart has gone beyond permission, so is a trespasser. And Lisa is a lawful visitor also. There are other things we need to consider, so as we go through we will consider those. But a reminder of the structure: identify the problem, this is one of occupiers liability, define what this is, explain the law which is relevant to each particular claimant, and apply the law too. Finally, we shall conclude. A quick exam tip then: if there's more than one claimant, identify who the lawful visitors are and who are trespassers first. So make sure you spend some time with the question before just going on and writing it. You might miss out some key bits of information should you not plan your answer first. You can explain why the group of visitors are visitors to save time doing it for each claimant. And then you should apply the law to each claimant in turn. Now that second point really is optional, isn't it? If you prefer to go through each particular game to turn and just to make sure you've hit every element for that person, by all means do so. But if there's a group of visitors and they're all the same kind of reasons for a visitor and you just slight adaptations, then you can do it as a group. So that, for example, Marge, Lisa and Homer are all lawful visitors because they have a contractual permission to be on the premises. However, the premises is different for each one. So we've got a kitchen, we have stairs, and we have the chalet. So therefore, we just could kind of lump them together if necessary, but if you feel more confident in doing each in turn, that's okay. Just make sure you spend the appropriate amount of time doing that. A quick note, again, you'll probably see this in all of my videos, but make sure you don't spend too much time with the facts of a case. Now, it is important to use case authorities. It's not important to discuss every fact you know about that case. You may, for example, feel very good that you've written a lot about lots of cases, you're looking back over your exam paper and thinking, I did well there, I wrote lots. But in fact, it doesn't raise AO2 in AQA, the application. It might not raise your kind of grade descriptor in AO3 where you're analysing the law. So be careful with the amount you say about the cases. The important thing about cases is to explain why the ratio decidendi is being used, or what that is, so the legal reason for the decision and how it supports your point. A third point, which I've not put on there, is don't put your case in brackets at the end of a sentence, because of course if you know that case supports your point, why not tell us why? Why not tell the examiner or your teacher why? So back to this scenario then. So we have this first one. We're going to deal with Homer. So he falls down steep steps that lead to a chalet from the road below. There's no guardrail to the steps and the steps are unlit. Homer suffers severe head injuries in the fall. So we need to first of all identify who are we suing, who are we laying the claim against. And this is of course Springfield. Okay, in terms of degree of control, Springfield are the owner. Now, if it's different, we can use Wheat and Lakoff for common law rules, but this is fairly obvious. In the scenario, it tells us they own and manage the premises. In terms of premises then, this is a bit of a complex one because stairs are a fixed structure, or at least should be. And in this case, of course, it is premises. So look carefully in your example, in your scenario. Is it the case that they are fixed in some way? And in that case, even if they're movable, or if they're attached to property, it's probably going to be premises. It's quite a broad church, that one. Let's look at why they're a lawful visitor or a trespasser then. What type of permission do they have to be there, or do they have no permission? Now in this case, they're a lawful visitor as home as a guest and therefore likely has contractual permission. We purchase a stay at a hotel, for example, or a holiday camp in this case, there's a contract there. This is express permission then. Now I mentioned earlier on that we then deal with these four, and well, the common duty of care always, and then the other three if they apply. If not, we leave them out. Common duty of care then, well, let's explain it. So we have a duty of care to make sure the premises is reasonably safe. And so in this context then, we could apply and say, well, a steep stairs with no handrail or lights is not reasonably safe. You know, we could use cases, Laverton and Rochester. In those cases, they were test cases in the sense which said that we don't have to keep cases perfectly safe, just reasonably so. So Laverton and Cleopatra take away Supreme with a wet floor, or Rochester Cathedral, so use cases to support your points. Now, there is a common duty of care. Is the claimant a child? Well, Homer is the father of the family, for those familiar with The Simpsons, so we don't use that, we don't approach it. Is the claimant a person exercising a trade or calling? Well, in this particular case, Homer is going up the stairs of the chalet, he's not performing his job, and therefore we don't use this one. But what if the claimant's injuries were caused by the negligence of an independent contractor? Well, again, no evidence of this one, so again, we don't apply. So we've dealt with the common duty of care. With Homer, we just need now to consider have they fallen below the duty, and of course they have. By not having safe stairs, that's without doubt falling below the standard of care expected. In terms of causation, factual causation is established, okay, because of course but for the rail being in that state, or the premises being in that state, Homer would not have been injured. And again, the damage is foreseeable. If somebody walks upstairs which are unlit and without safety, then some harm is foreseeable. And if some harm is foreseeable, you are liable for the likely extent or full extent. So in this case, Homer could claim for personal injury under the Occupiers Liability Act of 1957. But we do need to consider some defences. Now, actually, there was no warnings. There was nothing in that scenario to suggest some warnings. He hasn't contributed in any way because he's just simply gone up some stairs. And he's not consented to the risk either. And there is no exclusion clause that we know of, so we don't apply. So to conclude then, is there potential liability under the Act? Yes, there would be liability. Are there potential defences? No, on the face of it, none in that scenario. And finally, what are the possible remedies? Likely compensation for the personal injuries to Homer, and of course, in a larger form question, we need to go on about how this would be set out and the damages, how they'll be awarded and so on. But there's not enough detail in this particular one to be doing that. Okay, so let's go on to our second claimant, who is actually going to be Lisa for the purposes of going in order of the Act. Now, of course, if this confuses you, you go to Marge first, then by all means, watch the video section on Marge and then go through that one. Again, the occupier is the same. We know the owner, Springfield, has a degree of control, so therefore is the occupier. In terms of premises, identify why it's premises. Well, again, a chalet is a fixed structure. Remember, in this case, Lisa is outside of a chalet and she's eating some berries. Is she a lawful visitor or a trespasser? Again, the same as Homer. Likely she has contractual permission an express permission because she's a guest of the holiday camp. Now, we always need to use the common duty of care and apply, so that's what we're going to do first. Explain reasonable care, reasonable safety, and of course, in this case, consider that effect. So, again, reasonably safe is also outlined in case law, but leaving poisonous berries accessible to children directly outside of a door is probably not reasonably safe, so a duty then is owed. And this, of course, you might already know by now, but it's very similar to the facts of Glasgow Corporation and Taylor, at least with respect to a child eating berries. Now, we've said we only use the second, or the 2, 3, and 4 here, if relevant. We know Lisa is a child. Now, if you're not a Simpsons fan, Lisa is 8 years old and has been since the mid-90s or late 80s, so therefore she is 8 years old for the purposes of this question. So, if the claimant's a child, we need to be prepared for them to be less careful than adults. And so, in this context, we need to make it safe for a claimant of that age. Lisa's 8 and would of course not take the same level of care as an adult. The berries may be considered an allurement in some way. They're attractive to look at. And kids will be in grocery fruit, so therefore I guess pairing those two things together may be considered an allurement. Now in this case, parents might need to supervise. Now that could be something we discuss, something you could consider. Should they be told not to do it? Should they be looking at them all the time? My argument is probably not. So therefore in this case, the supervision of parents is not really going to remove liability. And as we know, Glasgow Corporation and Taylor is a key case here. Now the claimant is a child, but the claimant is not exercising a trade or calling. Lisa's not doing the job. What if the claimant's injuries are caused by the negligence of an independent contractor? Again, this is not applicable in this situation. Now, has the occupier fallen below the standard? Without doubt. Leaving berries accessible, we know through case law that they should take care. They haven't here. Factual causation is established. If the premises weren't as they were, as in berries being available, Lisa would not have been injured or had an upset stomach. The damage is foreseeable. The upset stomach, in those circumstances, it's quite likely that it could happen. So therefore, she could claim for personal injury under the Occupiers Liability Act of 1957. Again, similarly to Homer, there are no warning signs. There's no negligence on the part of Lisa. She hasn't consented to the risk, and there are no exclusion clauses that we know of, so no defences. So is there liability? Yes. Defences, no. And again, likely compensation for remedies to Lisa. Our final claimant with respect to lawful visitors is Marge. So she's inside the kitchenette in the chalet and she's badly burned when she plugs in the kettle. Now, it tells us also that Shoddy Electric Company have recently rewired the chalet. So this again is repetitive. We have the owner, Springfield, we have the premises. Well, this kitchenette is within a fixed structure or is a fixed structure, and so therefore is premises under the Act. Lawful visitor or trespasser. Identify whether the claimant is a lawful visitor or a trespasser in outline only. There may be more than one potential claimant. We've noted in what way is she? Well, she has contractual permission, and this is express permission. She's a holiday maker. We always need to apply the common duty of care, and in this case, we could argue that again, live wires being accessible or the plugs being unsafe is not reasonably safe. So therefore, a duty is owed, and again, that reasonable safety bar is proven by Laverton and Rochester Cathedral in two separate cases. Now, the claimant is not a child, so we don't need to consider this. Marge is the mother of the family. Is Marge exercising a trade or calling? No, she's not a tradesperson. And what if the claimant's injuries were caused by the negligence of an independent contractor? Well, we know Shoddy Electric Company has rewired the premises, so therefore Springfield Holiday Company might wish to negate liability through this clause in the Act, in the Occupiers Liability Act of 1957. So we then need to identify this. So has somebody else done the work? Yes. Shoddy Electric Company have rewired the chalet, which has caused the damage. Now, what the eventual result of this is, if successful, is the occupier is not liable, but we need to satisfy these three tests. First of all, was it reasonable to entrust the work? Now, the clue here is in the name. Shoddy Electric Company. Shoddy means bad, so it's probably not good to hire them, is it? Is the contractor competent? Again, they're called Shoddy Electric Company. Now, you may, in your scenario that you're looking at, have a situation where they have a bad reputation in some way, or it says they recently started out, or something along those lines, which would give you an idea of whether they're good or not. I mean, it's not as if we could go to a website such as like Trusted Trader and check if this particular person is competent, because inevitably it's going to be someone who's made up in your scenario. So probably then, and demonstrably not competent. They left the live wires. I mentioned earlier when explaining how this test works that the occupier must inspect the work if possible. Now in this case, there's no evidence that they did check the work, but if they did, they should have realised there was a live wire. It would have been easy to check. So therefore, they haven't satisfied any of these tests. So therefore, liability will not be removed. The occupier would still be responsible. So have they fallen below the standard? Yes. And again, but for the allowing this to occur, so but for the live wire being exposed, but for not checking the work and so on, but for the circumstances of the kitchenette, Marge would not have suffered harm. And so damage is foreseeable. So for example, in this particular case, electrocution and burns are foreseeable if there's a live wire in the premises. And so she can also claim for personal injury. But similarly to Homer and Lisa, no warnings, no net contributory negligence, no consent, no exclusion clauses. And finally then, conclude, is a liability? Yes. Defences? No. But if you felt it was successful, so obviously if it was a different scenario, and they had checked the work, the company was, the company was reputable, for example, then this would have removed the liability of the occupier, but it didn't in this case. And what about the remedies? Compensation for the burns. Now I mentioned that was the final person, or the final claimant, because Bart is a trespasser. So he's gone beyond permission by entering the kitchen. Now this is dealt with in a separate video, but let's look at why. So we've got occupier, it's still Springfield, it is premises. but he's gone beyond permission, so he's a trespasser, and so would not be able to claim under the 1957 Act. Now you can see the other video on the 84 Act for trespassers on how to apply the law to this particular claimant. Now, if you're interested in getting a written version of this, I'm quite happy to send you one. This is my email address, reasonabledanlaw@gmail.com. I send you the resources if you don't want to write this out, for example. If it was helpful, please keep using it. Obviously it's not going anywhere, so you can just use it with every new scenario. And as I say, if you want help with either negligence, or if you've done lawful visitors and you're now doing trespassers, there is another video on that too. So good luck in your work, either doing class activities, homework, revision, or indeed your exams. And thank you for watching.